Absent an express restriction in the lease, a tenant may freely transfer his leasehold interest in whole or in part. Whoa, okay, where are we? We're on page 61 of the BARBRI outline, reading about real property assignments and subleases. Absent an express restriction in the lease, a tenant may freely transfer his leasehold interest in whole or in part. If he makes a complete transfer of the entire remaining term, he has made an assignment. If he retains part of the remaining term, the transfer is a sublease. Example, L leases property to T for a 10-year term. 1 month later, T transfers his interest to T1 for 9 years, retaining the right to retake the premises reversion after 9 years. The effect of his transfer is to create a sublease between T, lessor, and T1, the sublessee. If, on the other hand, T has transferred to T1 for the remaining period of the lease, reserving no rights, the transfer would constitute an assignment of the lease from T, assigner, to T1, assignee. Note, it is not controlling that the parties denominate the transfer as assignment or sublease. The court still examines what interest, if any, is retained by T to determine the nature of the transaction. 1. Consequences of assignment. The label given to a transfer, an assignment, or sublease determines whether the landlord can proceed directly against the transferee or only against the transferor. To be an assignment, the transfer must be on the same terms as the original lease, except that the tenant may reserve a right of termination, re-entry for breach of the terms of the original lease that has been assigned, for example, to A for the balance of the leasehold term. However, should A fail to make the rental payments to the landlord, the right to re-enter and reclaim the premises is reserved. If the transfer is an assignment, the assignee stands in the shoes of the original tenant in a direct relationship with the landlord. The assignee and the landlord are in privity of estate, and each is liable to the other on all covenants of the lease that run with the land. So this is just so incredibly important. I'm rereading it. Okay, so unless restricted by lease, the tenant may assign or transfer. We know this. And we know what example 1 is and example 2. We know examples of this. What are the consequences of an assignment? The label given to a transfer, an assignment, or sublease determines whether the landlord can proceed directly against the transferee or only against the transferor. To be an assignment, the transfer must be on the same terms as the original lease, except that the tenant may reserve a right of termination, re-entry for breach of the terms of the original lease that has been assigned, for example, to A for the balance of the leasehold term. However, should A fail to make the rental payments to the landlord, the right to re-enter and reclaim the premises is reserved. If the transfer is an assignment, the assignee stands in the shoes of the original tenant in a direct relationship with the landlord. The assignee and the landlord are in privity of estate, and each is liable to the other on all covenants in the lease that run with the land. Covenants that run with the land. Rent covenant runs with the land. Assignment by assignee, reassignment by assignee, privity of estate with the landlord ends, and effective assignee assuming rent obligation. Original tenant remains liable. So, hold on. I don't want to go into all of this assignment stuff until we get into the sublease. Like, what's the outcome of the sublease? I can't find the demarcation, so I'm going to have to keep on just reading in the assignment section. A covenant runs if the original parties to the lease so intend, and if the covenant touches and concerns the leased land, for example, it benefits the landlord and burdens the tenant, or vice versa, with respect to their interest in the property. These requirements are discussed in detail in another section. Covenants held to run with the land unless the parties specify otherwise include covenants to do or not do a physical act, example, to repair, to conduct business on the land in a specified manner, or supply heat. Covenants to pay money, rent, taxes, etc., and covenants regarding the duration of the lease, example, termination clauses. Okay. Those are all examples. It requires such and concern, benefiting the landlord, burdening the tenant, or vice versa, with respect to their interest in the property. If it's intended to be a covenant between the landlord and tenant. Now, rent covenant runs with the land. Because the covenants pay rent runs with the land, an assignee owes the rent directly to the landlord. He does not owe rent for the period before the assignment, but only for the time that he is in privity of estate. Example, from the time of the assignment until the end of the lease, or until the assignee himself resigns. Reassignment by assignee in this section, privity of estate with landlord ends. If the assignee reassigns the leasehold interest, his privity of estate with the landlord ends, and he is not liable for the subsequent assignee's failure to pay rent. However, if the first assignee specifically promised the landlord that he would be liable for the rent for the remainder of the lease term, he may be obligated to pay based on privity of contract, even though his reassignment ended the privity of estate. Effective assignee assuming rent obligation. If the assignee made no promise to the landlord but did promise the original tenant that he would pay all future rent, the landlord may be able to sue the assignee as a third-party beneficiary of the contract between the original tenant and the assignee. This is all seriously so important. So play it back if you didn't catch this, how this works. Original tenant remains liable. After assignment, the original tenant is no longer in privity of estate with the landlord. However, if, as is likely, the tenant promised to pay rent in his lease with the landlord, he can still be held liable on his original contractual obligation to pay. Example, on privity of contract. This allows the landlord to sue the original tenant where the assignee has disappeared, is judgment-proof, etc. Example, L rents to T for 3 years at $9,400 per year. After 1 year, T assigns to T1. T1 pays the rent for 1 year and then assigns to T2. T2 fails to pay rent. L can collect from T or T2, but not from T1, unless T1 made some promise on the basis of which L can sue him. Consequences of sublease. In a sublease, the sublessee is considered the tenant of the original lessee and usually pays rent directly to the original lessee, who in turn pays rent to the landlord under the main lease. So those are the consequences of the sublease, is that the sublessee is considered the tenant of the original lessee and usually pays rent directly to the original lessee, who in turn pays rent to the landlord under the main lease. A, liability of sublessee for rent and other covenants. The sublessee is liable to the original lessee for whatever rent the two of them agreed to in the absence of... Oh my God. Whatever rent the two of them agreed to in the sublease. However, the sublessee is not personally liable to the landlord for rent or for the performance of any other covenant made by the original lessee in the main lease. The reason is that the sublessee has no contractual relationship with the landlord, no privity of contract, and does not hold the tenant's full estate in the land, no privity of estate. Therefore, the covenants in the main lease do not run with the land to bind the sublessee. 1. Termination for breach of covenants. Even though the sublessee is not personally liable to the landlord can still terminate the main lease for non-payment of rent or, if so stated in the lease, breach of other tenant covenants. If this occurs, the sublease will automatically terminate at the same time. B. Assumption by sublessee. It is possible for the sublessee to assume the rent covenant and other covenants in the main lease. An assumption is not implied, but must be expressed. If this occurs, the sublessee is bound by the assumption agreement and becomes personally liable to the landlord on the covenants assumed. The landlord is considered a third-party beneficiary of the assumption agreement. That's kind of new to me. Rights of sublessee. The sublessee can enforce all rights made by the original lessee in the sublease, but has no direct right to enforce any covenants made by the landlord in the main lease. However, it is likely, although there is very little case law on point, that a sublessee in a residential lease would be permitted to enforce an implied warranty of habitability against the landlord. Covenant against assignment or sublease. A. Strictly construed against the landlord. B. Waiver of covenant. And C. Continuing waiver. D. Transfer in violation of lease not void. And E. Reasonableness. So, covenants against assignment or sublease. Strictly construed against the landlord. Many leases contain covenants on the part of the tenant not to assign the sublease without the consent of the landlord. These are strictly construed against the landlord. Thus, a covenant prohibiting assignment does not prohibit subleasing and vice versa. Waiver of covenant. Even if the lease has a valid covenant against assignment, the covenant may be held waived if the landlord knows of the assignment and does not object. This often occurs when the landlord knowingly accepts rent from the assignee. Continuing waiver. If the landlord grants consent to one transfer, the rule in Dumpter's case provides that he waives his right to avoid future transfers unless he expressly reserves the right to do so. Reservation of right must take place at the time of granting consent. Transfer in violation of the lease not void. If a tenant transfers, assigns, or sublets in violation of a prohibition in the lease against transfers, the transfer is not void. However, the landlord usually may terminate the lease under either the lease terms or a statute. Alternatively, he may sue for damages if he can prove any. Reasonableness. In a minority of states, the landlord may not unreasonably withhold consent to transfers by the tenant. The majority imposes no such limitation. In the majority of states, that is. So, assignments by landlords is the last section before condemnation. A. Right to assign. A landlord may assign the rents and reversion interest that he owns. This is usually done by an ordinary deed from the landlord to a new owner in the building, unless required by the lease, which is very unlikely. The consent of the tenants is not required. B. Rights of assignee against tenants. Once the tenants are given reasonable evidence that the assignment has occurred, they are legally obligated to recognize and pay rent to the new owner as their landlord. This is called attornment. The benefits of all other tenant covenants, i.e. to repair, to pay taxes, also run the landlord's estate and benefit the new landlord, provided that they touch and concern the land. C. Liabilities of assignee to tenants. The assignee is liable to the tenants for performance of all covenants made by the original landlord in the lease, provided those covenants touch and concern the land. The burdens of those covenants run with the landlord's estate and become the burdens of the new landlord. The original landlord also remains liable on all of the covenants he made in the lease. So that part's in bold. The original landlord also remains liable on all of the covenants he made in the lease. So this assignee is not a prior mortgagee or have paramount title. He bought paramount title through the assignment, but still the landlord has the covenant of quiet enjoyment burdening him. L leases a T as an example, and in the lease covenants to repair and maintain the premises. L then sells the building to L2, subject to the lease. Because a covenant to repair and maintain touches and concerns the land, L2 is personally liable to T if L2 fails to perform the covenant. L also remains liable, probably by privity of contract, even though it's just doesn't seem equitable. Anyway, condemnation of leaseholds. Entire leasehold taken by eminent domain, rent liability extinguished. If all of the lease land is condemned for the full balance of the lease term, the tenant's liability for rent is extinguished because both the leasehold and the reversion are merged in the condemnor, and there is no longer a leasehold estate. Absent a lease provision to the contrary, the lessee is entitled to compensation for the taking of the leasehold estate. Temporary or partial taking, tenant entitled to compensation only. If the taking is temporary, example for a period less than the remaining term, or if only a portion of the leased property is condemned, the tenant is not discharged from the rent obligation but is entitled to compensation, which is a share of the condemnation award for the taking. Part G, this is the last part of landlord-tenant, which discusses tort liability of landlord and tenant. Landlord's liability. At common law, subject to a few exceptions, the landlord had no duty to make the premises safe. Today, there are 6 exceptions to this rule. Right? As I said, common law, no duty to make the premises safe. Now there's 6 exceptions. I'm going to read them all. Concealed dangerous condition, in parentheses, that's a latent defect. Common areas, public use, furnished short-term residence, negligent repairs by the landlord, and lastly, landlord contracts to repair, which is what I said at first. If a landlord covenants to repair, most courts hold that he is liable for the tort for an injury to the tenant or the tenant's guests resulting from his failure to repair or negligent repair. Going back to the top, concealed dangerous condition, latent defect. If at the time the lease is entered into, the landlord knows or should know of a dangerous condition that the tenant could not discover upon reasonable inspection, the landlord has a duty to disclose a dangerous condition. Failure to disclose results in liability for any injury resulting from the condition. Once disclosure is made, if the tenant accepts the premises, she is considered to have assumed the risk of injuries to herself or her guests. For example, family members, invitees, licensees. The landlord is no longer liable. Common areas are B. The landlord has a duty to exercise reasonable care over the common areas such as halls, walks, elevators, etc. that remain under his control. The landlord is liable for any injury resulting from the dangerous condition that could reasonably have been discovered and made safe. This duty is the same as the duty an owner-occupier owes his guests. See the multi-state torts outline. C. Public use. A landlord is liable for injuries to members of the public if at the time of the lease he, Romanet 1, knows or should know of a dangerous condition. Romanet 2 has reason to believe that the tenant may admit the public before repairing the condition, example, because of short lease term. And Romanet 3 fails to repair the condition. The landlord's liability extends only to the people who enter the premises for the purpose for which the public is invited. Note that the tenant's promise to repair does not relieve the landlord of liability if the landlord has reason to suspect that the tenant will admit the public before making the repair. D. Furnished short-term residence. When a furnished house or apartment is leased for a short term, for example, 3 months or less for immediate occupancy, many jurisdictions hold that the landlord is liable if the premises are defective and cause injury to the tenant. 5th, E. Negligent repairs by landlord. Even if landlord has no duty to make repairs, a landlord who actually attempts to repair is liable in If an injury results because of the repairs were done negligently or because they gave a deceptive appearance of safety. Restatement second, a property landlord and tenant, section 17.7. Example, L leases an apartment to T. Without obligation, L agrees to repair sagging rotted boards on the kitchen floor. The work appears to be done correctly, but in fact structurally unsound. T relies on the deceptive appearance of safety thereby created and walks on the floor. L is subject to liability for injuries to T when the floor collapses. We read landlord contracts to repair. The modern trend, general duty of reasonable care. Increasingly, the courts are simply holding that landlords have a general duty of reasonable care with respect to residential tenants, and that they will be held liable for personal injuries of tenants and their guests resulting from the landlord's ordinary negligence without regard to the exceptions discussed above. This duty is ordinarily not imposed until the landlord has notice of a particular defect and a reasonable opportunity to repair it. A, B, and C. A, defects arising after tenant takes possession. A landlord will generally be held to have notice of defects that existed before the tenant took possession. However, the landlord will not be liable for defects arising after the tenant took possession unless there is evidence that the landlord actually knew or should have known of them. B, legal duty to repair. If the landlord has a statutory duty to repair, example in our housing code, he may be liable to the tenant and the tenant's guests for injuries resulting from his failure to repair. Some courts hold that violation of the housing code or similar statutes is negligence per se, but most courts hold that it is merely evidence of negligence, which the jury may or may not find conclusive. The same analysis probably applies to a violation of the implied warranty of habitability, but there are very few cases on point. Security. Some cases have held landlords liable for injuries inflicted on tenants by third-party criminals where the landlord failed to comply with housing code provisions dealing with security or failed to maintain ordinary security measures such as working locks on apartment doors, or where he advertised extraordinary security measures, for example, TV surveillance, doorman, security patrols, and then failed to provide them. Tenant's liability. The tenant, as occupier of the premises, may be liable towards a third persons for dangerous conditions or activities on the leased property. The duty of care owed by the tenant as an occupier of land is discussed in the multi-state torts outline. So we reached fixtures, which is basically the end of the part that I am going to be reading. What is this? Literally no end. Okay. There's some things that, nonetheless, I wasn't sure if we got to, and thus wanted to read now, such as equitable servitudes. That is only 2 pages, talking about the creation, requirements for the burden to run, requirements for the benefit to run, equitable defenses to enforcement and termination. I want to read that because I don't believe that made it in. And I think that's about it now. Conceptually, that would be on page 38, which I already passed. So that's why I apparently am looking at the wrong outline. And thus, we're going to go to page 38 of this outline to cover that section. And if it's not here, then we've lost our opportunity to cover it. And let's hope it's in one of the previous recordings. So, found more things to hang on the wall. Equitable servitudes. An equitable servitude is a covenant that, regardless of whether it runs the land at law, equity will enforce against the assignees of the burdened land who have notice of the covenant. The usual remedy is an injunction. Exam tip. A single promise can create both a real covenant and an equitable servitude. For the bar exam, the main difference between the two will be the remedy sought. If money damages are sought, you should use the the real covenant analysis. If the party seeks an injunction, you should consider whether the requirements for enforcement as an equitable servitude have been met. Creation. Generally, as with real covenants, equitable servitudes are created by covenants contained in a writing that satisfies the statute of frauds. There's one exception. Negative equitable servitudes may be implied from a common scheme for development of a residential subdivision. Thus, if a developer subdivides lands and some deeds contain negative covenants while others do not, the negative covenants will be binding on all parcels provided there was a common scheme of development and notice of the covenants. Common scheme, reciprocal negative servitudes will be applied only if at the time that sales in the subdivision begin, the developer had a plan that the parcels would be subject to the restriction. The scheme may be evidenced by a recorded plat, a general pattern of restrictions, or oral representations to early buyers. Exam tip: if the scheme arises after some lots are sold, no implied servitude can arise with respect to the lots already sold without express covenants. So remember, if lots 1 through 5 are sold without a restrictive covenant, and the deeds to lots 6 through 50 contain one, the covenant cannot be enforced as a servitude against the owners of lots 1 through 5. Notice: to be bound by a covenant not in her deed, the grantee must have had notice of the covenants in the deeds of others in the subdivision. Notice may be actual direct knowledge of covenants, inquiry, neighborhood appears to conform to common restrictions, or record prior deed with covenant in grantee's chain of title. For the requirements for the burden to run, a successor of the promisor is bound if the covenanting parties intended that the servitude be enforceable by and against assignees. That's intent and notice. The successor of the promisor has actual inquiry or record notice of the servitude and touches and concerns the covenant touches and concerns the land. It restricts the holder of the servient estate in his use of that parcel. So the acronym is INTC, or the mnemonic is INTC. For the benefit to run, it's only ITC. So notice isn't required. The benefit of an equitable servitude runs with the land and thus is enforceable by the promisee's successors if Romanet 1, the original party so intended, and Romanet 2, the servitude touches and concerns the benefit of property. Exam tip: in contrast to real covenants, which require vertical and horizontal privity of estate for burdens to run, the vertical privity for benefits to run, no privity of estate is required for an equitable servitude to be enforceable by and against assignees. Now there's a checklist for the requirements of intent, notice, touch, and concern, horizontal privity, and vertical privity. The privity part just does not apply to the equitable servitudes, and that's what basically we just read. Whereas the real covenants, for the burden to run, there needs to be horizontal and vertical privity, but for the benefit to run, only vertical. So equitable defenses to enforcement. A court will not enforce an equitable servitude if these equitable defenses apply. The person seeking enforcement is violating a similar restriction on his own lands, which is unclean hands defense. Right, so he's violating a similar restriction on his own land. B, a benefited party acquiesced in violation of the servitude by one burdened party. C, a benefited party acted in such a way that a reasonable person would believe the covenant was abandoned or waived. That's estoppel. The the equitable defense of estoppel. There's latches, and also that the neighborhood has changed so significantly that enforcement would be inequitable. So for and D, latches, the benefit party fails to bring a suit against the violator within a reasonable time. Any of those. So that's an or, which is a disjunctive rule or list, I'll say. And then termination, like other non-possessory interests, and equitable servitude may be extinguished by, I see three things here. 1, a written release from the benefit holders. 2, merger of the benefited and burdened estates. Or 3, condemnation of the burdened property. Now, real covenants and equitable servitudes are displayed in a table on the next page, along with other non-possessory interests, including easement, license, and profit. There's a lot of writing about or readings about these easements, licenses, and profits. The definition of each I'm going to give right now. An easement is a grant of an interest in land that allows someone to use another's land. A license is permission to go onto another's land. Profit is the right to take resources from another's land. And a real covenant or an equitable servitude is a promise to do or not to do something on the land. There's examples. I'm skipping them. Writing is required for everything except license. A license is not required to be in writing, but an invalid oral easement turns into a license. For an easement, a writing is generally required, except when the easement is less than 1 year, by implication, necessity, or prescription. And those are ways. The implication, necessity, and prescription are ways that the easement is created. There's one exception to a writing for the real covenant and equitable servitude. The equitable servitude may be implied from a common scheme of development of residential supervision. Now, how do you terminate these things? Easement, stated conditions, release, merger, abandonment, estoppel, prescription, and end of necessity. The mnemonic for this, from my memory, is end cramp. So let me just try to remember it. E in end cramp stands for estoppel. I know that because I'm looking at the paper. But N stands for necessity. D stands for, I think, destruction or condemnation. Cramp. C, that could be condemnation, but here it's going to be conditions being met. Cramp. R, release. A, abandonment. Cramp. M, merger. And P is prescription. I had to look at that. License is terminated. It's generally a revocable at will and may be irrevocable if it's coupled with an interest or if the licensor is stopped by the licensee's expenditures. And then profit is the same as easement. And cramp again. And then to terminate a real covenant equitable servitude, the options are release, merger, condemnation, and also an equitable defenses may apply to the enforcement of a servitude. So that's going to be all that I record for real property. The next thing I'm going to do is put these recordings in order. Actually, I might read my own outline. I've read BARBRI. I've combined the reading of like 2 of 3 different BARBRI outlines, but I myself have written an outline of the case book for fall and spring semesters. It is incredibly long. I mean, it is very long. So try to see if you can't do the important parts perhaps, but it may just confuse me, so we'll think